if you do encounter a legal matter or you're thinking about drafting your policies and procedures, which we'll talk about here in just a second, make sure you consult with the general counsel or some other retained attorney. Here's what it all boils around, though. There's always some form of negligence, recklessness, or carelessness. Now, what is that? Okay? Well, let's look at what the definitions are, and let's look at what some actual cases have established regarding this. Now, negligence, and this is what we talked about, or I wanted to alleviate it on earlier. Let me see, one of these is a laser pointer. There we go. What is the standard that we want to establish as strength and conditioning coaches? Okay? And keep that in mind. There is the recklessness that when we create some type of situation and there's a conscious disregard for some dangerous situation that we've created, then that's reckless. Okay? And careless. We did something we shouldn't have done, or we should have done something and didn't do it. That's what careless is. The main thing that I want you to understand is, what is negligence? Well, there's a certain standard perceived by what a strength and conditioning professional should be. Okay? And if you did not adhere to that standard, then that's when you expose yourself to liability. There's an echo there, wasn't it? Now, when we talk about these cases are only allegations. It doesn't mean it's true. Now, if you're ever served with a petition where you're being sued for negligence or whatever it may be, and you're listed as a defendant, don't freak out, okay? Because these petitions are like a kid's Christmas wish list, okay? Or like sometimes when you're hired at a new school, they say, hey, we're going to make this building a weight room, and you're going to be able to stock it with whatever you want to, and you're just writing down this big list of what you're going to do, and you get there, and you realize you can only get part of it. Well, that's what a petition is. There's all types of things alleged, but the attorney knows he can only prove a few of them. Okay, he's just trying to create some commotion. He's trying to get some people to panic a little bit, so they'll think, okay, we need to settle this thing because I don't want to lose everything today. Okay, I don't want to lose everything, so let's settle this. Look what all they got listed here. Okay. Now, one case was a USC spotting case that occurred out at the University of Southern California. The alleged incident date, September 28, 2009. I'm not going to read all this to you. And you can see here, and my legal assistant made it where just one thing goes up at a time. I usually like for all of it to go up there, so I'm probably going to put the whole thing up and just talk to you about it once I get it up there. But one of the allegations here was that the player was relying on what? The strength and conditioning coach's previously represented abilities and competence. That's the standard that we're talking about in negligence. Okay, there was a standard here, there was an expectation, and based on this allegation in this petition, the assistant strength and conditioning coach didn't comply with it. Now, I've been there. Okay, I've been there when we've got tons of people in the weight room. You look around, it's just supposed to be a warm-up. You look over there, guy's doing a power clean. Next thing you know, he flies back and the bar pins his neck to the ground. I mean, we've all had incidents happen. Okay. This just happens to be an incident where the player supposedly had an NFL career, and so the suit was filed here, and the allegations were, just as we talked about, negligence, recklessness, and carelessness. That was later settled. And notice here the defendants. USC is a private institution. Okay, so the assistant strength coach here was also listed as one of the defendants as well. Now, we all hear that, hey, they signed a waiver. We're okay. We got everybody signed a waiver. But here, the defense argued throughout the settlement negotiations, because this never went before a jury. Okay, throughout the settlement negotiations, it was not enough that the player assume the risk. So just because you have a waiver signed, don't rely on that. And I'm going to show you how get around that. Now, just bear with me here, just legal mumbo jumbo. Let me sum it up. Sovereign immunity. There's two types of institutions, right? Some of you work at private schools, some of you work at public schools. So if you work at a private school and you think, well, we can't be sued anyway, well, that's true. There's sovereign immunity. However, notice what's happened in Texas. If the governmental unit can be sued as a private person because of negligence, then the institution can be sued for negligence. Now, there's not going to be any indemnification, which means that if there is some type of liability, that the institution will pay the damages for you if there's gross negligence. Now, an attorney is not going to go after you probably. I mean, there's some salaries out there where they're going to want to go after you or allege gross negligence, but they're probably just going to allege simple negligence. All right? So when you do go somewhere, and if you do work for a private institution, make sure you have an indemnification clause in your contract. So if something does happen, you're not going to be personally liable. Okay? It helps protect you. Say, well, if there's simple negligence alleged, something happens to one of the student athletes, am I going to be personally liable? Is there an indemnification clause to where you can jump in and you'll pay the damages? Definition there, what gross negligence is. If you can figure that out, let me know. Now, private institutions, of course, we just talked about sovereign immunity will not apply, so they don't have to, there's not a hurdle there to where the plaintiff has to establish that the entity can be sued as a private person, just like we had in the definition with the Texas Civil Practices and Remedies Code. Athletic associations, sovereign immunity will not apply. Now, here's another thing. If you're at a public institution and there is an association established, and I'm sure it was done for tax purposes, then case law's reason that sovereign immunity does not apply. Now, why does that matter? Because in a lot of cases, if it's a governmental entity that you're suing, that's being sued, excuse me, I'm not talking to attorneys today, that's being sued, then a lot of times there's a cap on damages. Okay, so there's a cap, say $200,000. I know in Florida it's $200,000. And if there's no sovereign immunity, there's not going to be any cap on damages. So if you're at a public institution and they're thinking about privatizing the athletic association, say, well, wait a minute, let's not do that yet. Now, wrongful death is where the liability comes in. We've had numerous deaths occur, especially on the collegiate level, since the year 2000. I think there's been 21. And I think 11 of them have occurred, what I'd read, 11 of them have occurred in the first 2 or 3 days of the strength and conditioning activity. So let's look at that and analyze what we can do to help avoid liability. There has to be a causation. They have to prove that you caused the death. So it has to be that allegation. And once that allegation is there, they have to prove that you caused it. There's things you can do to avoid it, to protect yourself. Let's look at a high school case there in Florida. Now, if you look at that, just looking at the allegations, not saying it's true, but looking at the allegations, there was a prior warning there, wasn't there? There was, a year earlier, the student athlete was hospitalized for heat stroke. So when it's the next summer or in the following workouts, you need to have some type of adaptation for that athlete, that student athlete, or you need to carefully watch he or she to make sure that they're okay throughout the workout. Same thing with the Georgia case. The thing with the Georgia case was the emergency action plan, which we've seen from the NCAA. Make sure you have an emergency action plan established. Now, when I was playing, when I was sitting on the bench at the University of Southern Mississippi, there was a death that occurred with Eric Sorey. And I can remember when he fell out that day. It was a mile run. It was the first run that had occurred when we reported back in the fall. And I saw the mannerisms and saw how his body language as that was occurring. So make sure you're aware of the difference between when someone is just tired and someone is exhibiting some form of significant medical problem. Okay? Make yourself aware of that. Make your staff aware of that. There was a Florida State case back in February of 2001 with this incident. Let's look at the allegation here. Remember we talked about causation? Medical examiner stated that sickle cell trait may have contributed to the player's death. Now, this case settled. It was a $2 million settlement, but based on Florida law, they could only collect $200,000. That's what I was talking about with the sovereign immunity issue. And it's still unresolved because now the legislature has to pass a bill to award the other 100 and the remainder, $1.8 million, to the family. But with the sovereign immunity, don't think you have protection just because you're at a public institution. That's one of the main things I'm trying to get across to you as well. Aaron O'Neill at the University of Missouri, another one. The main allegation here was the emergency action plan. I'm not saying it wasn't followed. It's just an allegation. If anybody here is from Missouri or knows somebody there, I'm not saying that that occurred, but that's what was alleged. So what do you need to make sure you have in place? An emergency action plan, and you know exactly what it is, and your staff members know exactly what it is, and I would even suggest going through some drills with it from time to time throughout the year. Documenting that so if something does happen, because let's face it, we're not going to be able to prevent deaths 100%. We're just not going to be able to do it. They're going to continue to happen. Okay? Especially when you're responsible for preparing these student athletes to get on the field or get on the court or wherever they may compete, then you've got to get them at a certain level, both mentally and physically. So we're not going to prohibit it altogether, but there are some things that we can do. We can have that emergency action plan in place, and everybody can know what it is, all your staff members, and I'll show you how to address that in your policies and procedures manual here in a minute. Premises liability. Anytime somebody comes in your weight room, you're responsible for it. Now, if it's like me, okay, I could lock that thing down. I mean, I could have everything locked. I would think I know who all had keys, and somehow when I come back in that weight room, something was moved. It was like there was a magic door in there somewhere. I don't know if you had that same problem. Or you'd come in there and it'd be an assistant coach with his family, and they're using the lat pull down as a rope swing going back and forth. And you're like, well, what's going on here? I don't know how they get in there. But think about with premises liability, equipment purchase. Okay, the type of equipment you're purchasing, we'll talk more about that in a second. Your maintenance and your policies and procedures manual, have it documented how often we check each machine. Every Friday at 3 o'clock, it's checked. Okay, we check the screws, we have to make sure everything's tight. Because if something happens, you've got it there to where you've done everything possible to prevent it. And if you've done everything possible to prevent it, you're going to make some lawyers out there discouraged because they're not counting on you dotting your I's and crossing your T's, and I wanted to make sure you do it. Okay, and that's when I talked with Peter, he felt the need as well. Equipment cleaning, we all know they come through. There's some people have certain diseases or things that can be contagious. So have your equipment cleaning, and there's OSHA standards out there that if there's blood present, make sure you follow those. I mean, look at, or just have it in your policies and procedures manual that's how it's conducted, that a cleaning is done with whatever type solution, and it kills all viruses and bacteria because it will protect you. And then the access. Do everything you can to prevent access from just anybody. I know back when I was coaching, it seemed like everybody in the world had weight room keys. And what you need to do, if a higher administrator is going to do that, just send them a memo to say your recommendation is that that's not followed, and just let it go with that. You probably won't ever hear back, but at least you've done everything possible to protect yourself. And that's the key. Products. Make sure when you buy a piece of equipment that it's from a reputable manufacturer. For some reason, I would get calls when I was a strength and conditioning coach, and they would say, there'd be some local guy that had been playing with a welder somewhere. He said, hey, this high school team here, nobody's crossed the 50-yard line on them in the last 10 years. They use this leg press. I'm not going to charge you anything. Is it okay if I put it in there? Because they want to list that it's in your facility. Don't do it, even if it's the old buddy from high school. Don't do it, because you need to make, at this day and time, you need to make sure you get your equipment from a reputable manufacturer. Let's look at this. You remember, are y'all aware of this aluminum bat case that occurred up in New Jersey? Where there was aluminum bat used, and supposedly it was dangerous, and it came back and struck a 12-year-old kid. And unfortunately, there was some permanent damage. The thing that I want you to get out of this is, look who all was sued. You have the manufacturer, a sports retailer, and the Little League entity. Okay, and it settled for a substantial amount of money. But what does that tell you? That if you're an entity that's utilizing the product, you could also expose the institution to liability. So just make sure it's from a reputable manufacturer. And document that it is. Now, with equality, and we're talking about gender, race, in this situation, on the top there, we have Title IX. We all have heard of that. Just want to give you some reminders. In your policies and procedures manual, don't be extremely, extremely specific about football and then very general about everything else. Okay, you're opening yourself to liability right there from a Title IX perspective. Because Title IX doesn't just apply to public institutions. It applies to public and private because they all receive federal funding. So make sure you're very specific that it is equal across the board. And I know when I was a strength and conditioning coach and I was at TCU or wherever I was, I always made sure that I had a female team that I coached as well. For two reasons. Okay? For some reason, I don't know if they're still like this, but men, they were at the Padres last year. Men, you got to tell them 100 times. Ladies are so nice because you tell them one time, they do it perfect, it seems like. Okay? So it's, for my sanity, I mean, it was great. I loved it, so I always make sure I did that. Plus, they worked hard. They worked extremely hard, usually more consistently than males, from what I saw. Don't get mad at me, males. Now, with employment, we've got to make sure they're qualified, obviously. And don't have any exceptions on that for the old buddy that's, he normally has a D-line job, but he needs something temporarily until he gets. Don't take any chances. Okay? Make sure they're qualified, certified strength and conditioning specialist. If I were you, I would make sure I'm certified with distinction every year, because that shows you're doing everything you can to be certified to the highest. And of course, the AED, CPR, first aid, all of that, make sure that that's there as well, and that none of those run out. Okay? With equal opportunity, when you hire an assistant or when someone is being hired, always make sure you have a diverse applicant pool. In other words, you have applicants from all races, genders, or you at least give it a reasonable time for that population to apply. Don't rush it. Don't say, oh man, we start, the guys, they're going to be here Monday. I got to have this guy left. I got to have somebody in here. Find some way to make do. Don't rush them to get them in there, because then you have a Title VII Civil Rights Act 1964 issue. Because it's got to be fair and equal. I don't know what's going on with the disparate impact. I don't know what's going on with all these unpaid intern deals. It's like the free, if that's what it took to get in when I was starting, I wouldn't have ever gotten the strength and conditioning profession. Because who can afford that? And here's your risk. And here's what I would look at across the board. And I'm talking more specifically with college here. Look across the board and see the race and gender of the large percentage of these unpaid interns. Because what happens with unpaid interns? They get the recommendations. They usually hang around. If they hang around long enough, they usually get a full-time position. Okay. Now, is there any intent there to discriminate? No. But on a disparate impact case, there doesn't have to be any intent. So if, oh my goodness, 5 minutes. So if a while from now, or if say 10 years from now, if you look and see that most of them are Caucasian males, for example, then you've got a disparate impact issue. Always warn. It can be on your bulletin board. It can be on your website. Always warn regarding these specific issues. Okay? It can be a simple bulletin board there in your weight room, but make sure they read it. Now here's your manual. Make sure all these areas are covered. From your emergency action plan all the way down, and make sure your staff knows exactly what to do in each situation. Okay? One of the most important here is your workout progression after concussions, rhabdomyolysis, or heat-related problems, dehydration. Okay? Make sure you note on there how you progressively get them back in their normal routine.